Hello, everyone. Thank you for joining the call today. Before we begin, we're going to go through a few housekeeping and intro items. Today's call is going to be around what you need to know about the FCC's TCPA declaratory rulings. Audio is being provided by VoIP, voice over IP. Be sure to turn up your sound on your speakers. If you have any audio or technical difficulty, please click the help widget at the bottom of the screen. It has a question mark icon and covers common technical issues. If you're unable to resolve the issues or have any questions during the webcast, you can click on the Q&A widget at the bottom and submit your questions. We will try to answer all questions during the webcast, but may run out of time, so we will reply via email after the presentation if we don't get to your question. Lastly, an on-demand version of the webcast will be available and sent to your email in the next few days. So before we begin, I'm just going to go through some brief introductions of everyone who will be speaking today. First is Becky Burr. Becky is Neustar's Chief Privacy Officer and Deputy General Counsel. As Neustar's Chief Privacy Officer, Becky is responsible for ensuring that the company maintains state-of-the-art privacy practices that always protect consumers and consumer information. She's a veteran of the FTC and the Commerce Department's National Telecommunications and Information Administration. At the FTC, Ms. Burr was responsible for competition and consumer protection policy in connection with information industry / electronic information infrastructure. She participated in developing the FTC's approach to competition, consumer protection, and privacy data protection in the digital marketplace. Also on the call is Mark Brennan. Mark is a partner at Hogan Lovells. His practice encompasses communications and consumer protection with a focus on legal frameworks applicable to digital and mobile platforms, international communications regulation, and mobile financial services. Mark has substantial experience assisting clients with complex consumer protection issues that span multiple fora, including the Federal Communications Commission, the FTC, the NTIA, Congress, state authorities, and the state and federal courts. He represents his clients on a wide array of regulatory and commercial issues related to the Telephone Consumer Protection Act, telemarketing issues, telecommunications licensing, mobile applications, and location-based services, spectrum policy, equipment development, and data privacy and security matters. He regularly advises clients in all segments of wireless and customer engagement ecosystems, including wireless carriers, global telecommunication providers, technology vendors, and application developers, as well as a diverse set of international clients from the transportation, financial services, education, and healthcare sectors. And my name is Tom Nowazik. I'm the Senior Product Manager at Neustar for our Business Assurance line of offerings that includes our Telecommunications Protection Act compliance solutions. So a little bit about Neustar as we begin. So Neustar is a leading provider of real-time identity data used in compliance and operations and marketing solutions. Neustar's authoritative intelligence powers clients' TCPA risk mitigation efforts by verifying consumer data and appending insightful attributes as whether a phone has been active or has been recently disconnected. Many of the largest corporations in the U.S. use Neustar's data to verify they are contacting the correct consumer to mitigate TCPA risk and increase operational efficiency. For more information, we'll provide contact information for Neustar at the end of the presentation. So now that we've kind of gotten through the bio of kind of everyone on the call and who Neustar is, let's talk a little bit more about Neustar before we kind of get into the question and answer. The first thing is you may not have heard of Neustar, but you probably interact with Neustar every day. Neustar is a large player in the telecommunications industry. We power 70% of all caller ID in the U.S., so that's kind of when we place a phone call, we have an identity, and we kind of provide that identity data over the phone line. We enable 7 billion text messages, 4 billion phone calls, and over 1.4 billion daily real-time verification queries. And so the reality is our data is really what makes us unique. We manage unique, accurate, and authoritative data sets which help inform high volume and high value decisions for our clients. Our clients utilize our cloud-based tools to get actionable data-driven insights to make informed decisions across their channels. So if you look at the slide, you really see that we have a lot of unique data sets here on the left that really drive our solutions. And these data sets are around identities, phone numbers, addresses, and names. And then we use proprietary technology to kind of build these linkages around these individual identifiers to drive identity data that can help you verify who you're about to place an outbound call to. So more specifically, is this Tom's phone number? And our clients use this data to help drive their business decisions and their operations. Sorry, we're going a little slow here. Here we go. Okay, Becky and Mark.
Thanks very much, and good afternoon, everyone. Thank you again for joining us for this webinar. My name is Mark Brennan, and I'm a partner at Hogan Lovells US LLP out of our Washington, D.C. office, and I'm delighted to be here with everyone. Today we're going to discuss the Federal Communications Commission's July 10th release of the Declaratory Ruling and Order on TCPA issues that it voted at its June 18th, 2015 meeting. As part of this webinar, I'd like to first spend a few minutes giving those of you that may not be familiar a few minutes of background information on the relevant TCPA requirements that drove much of the discussion and debate leading to this decision, as well as an overview of the FCC's decision, honing in on a few key issues listed on this slide, and then we'll cover a few additional items. All of this in brief, to be followed by a question and answer session with Becky Burr, and then we'll open it up for additional questions from the audience. So with that, let me dig right in. As many of you know, Congress enacted the TCPA in 1991 specifically to curb aggressive telemarketing practices. There were three areas in particular that caused significant concern. First, parties were using automatic dialing equipment to make unsolicited calls to random or sequential telephone numbers. Second, a number of callers were placing calls to numbers in sequence in a way that tied up a block of telephone numbers and created public safety risks. For example, calling the numbers in sequence would often be associated with calling all of the lines in a particular building or in a neighborhood, and again, that created some of the public safety risks. And then finally, again, this was 1991, and there were concerns about telemarketers shifting some of the calling costs onto wireless consumers, who, as many of you may know, wireless plans at the time often required per-minute billing, including for incoming calls. So the TCPA imposes a number of restrictions on telemarketing calls, faxes, and other outbound communications. Some restrictions apply not only to telemarketing calls, but also to non-telemarketing calls. And again, keep that in mind as we go through some of these specific requirements, because that's what drives some of the headaches and compliance challenges in this area. And under the TCPA, the Federal Communications Commission is tasked with implementation of some of the key provisions. So for our discussion today, there are two key requirements that the TCPA sets forth that again drive a lot of the compliance challenges, a lot of the litigation, and a lot of the activity in this space. I tend to think of them in terms of the wireless restriction and the wireline restriction, or residential number restriction. So wireless and landline, with the wireless restriction being far more restrictive on the caller. So on this slide, we have the wireless restriction. The TCPA says no autodialed or pre-recorded or artificial voice calls to wireless telephone numbers absent an emergency or prior express consent. Now, there are some other types of numbers that are subject to the same restriction, patient rooms in a hospital, the public safety answering point telephone numbers, and so forth. But again, for our purposes, the key restriction here is that if you are placing a call to a wireless telephone number, you need prior express consent for autodialed or pre-recorded calls unless it's an emergency. This restriction applies regardless of the content of the call. So it includes collection and servicing calls, and the FCC and some courts have determined that this applies to text or SMS messages. So it's not just voice calls, it's text messages as well. And in 2012, the FCC adopted additional written consent rules that apply to auto-dialed or pre-recorded telemarketing calls to wireless telephone numbers. That's the wireless restriction. The landline restriction is more permissive, and the combination of the TCPA as a statute plus the FCC's 2012 rule changes have created a structure for the calls to landline that effectively says no pre-recorded or artificial voice calls to residential or landline telephone numbers without prior express written consent. The exceptions are listed on the slide, but ultimately for the landline calls or calls to landline numbers, you don't have to worry about whether you're using an autodialer. You do have to worry about this restriction if you're using a pre-recorded or artificial voice message, and you only have to worry about it if it's a marketing call. So non-marketing calls or calls with an autodialer are not at issue in the landline restriction. So just to recap, two sets of requirements, wireless and landline. Wireless applies to autodialed or pre-recorded calls and applies regardless of the content of the call. And there are more burdensome requirements if it's a marketing call. And then for the landline calls, it's only a matter of whether you are placing pre-recorded marketing calls. So that brings us to the FCC's July 10th ruling. Just as a procedural matter, the decision is a declaratory ruling and order. The impact of a declaratory ruling is immediate and retroactive. Ultimately, the declaratory ruling translates to the FCC intending to clarify the law as it is on the books today and as it has always been under the current language or regulations at issue in the decision. So the decisions that the FCC makes in this order are almost all retroactive. The order part of this title refers to the prospective exemptions that the FCC granted. And we'll talk a little bit more about those later, but there are some areas where the FCC granted some exemptions from the prior express consent requirement on calls to wireless phones. Those are prospective only, and that makes sense as you think about some of the conditions that the Commission imposed. But ultimately, keep in mind that everything else in the order is applicable to calls already made, calls you make today, and calls you make going forward. As I mentioned, this order was effective on the day it was released, so July 10th, 2015. There have already been 3 appeals filed in response to the order. Those appeals have now been consolidated in the D.C. Circuit. The window in which parties can appeal is still open, so if there's anyone out there that is considering filing a court appeal of this decision, you have until early September to make your filing. But the window for having an opportunity to provide input on the venue for the decision has already passed. So as far as the key issues, I mean, this is an 80-plus page decision, and we're going to give a flyover of some of the key items that affect a broad array of parties. But again, there'll be time for Q&A afterwards, so certainly feel free to ask us anything that we can be helpful on. And I need to mention that I cannot provide specific legal advice to any individual parties, but I will do my best to provide helpful answers on any of the questions you may have. On the issue of what is and is not an automatic telephone dialing system, there was a lot of dispute and debate in the record on this issue. A number of parties filed petitions asking the FCC to clarify this because some of its prior rulings had not created bright line guidance for callers. And unfortunately, I'm not sure that we have bright line guidance after this order either. And that's one of the frustrations that I know a number of parties have faced. This section of the decision is confusing, convoluted. It references itself in conflicting ways. But regardless, there are a number of takeaways that we should keep in mind. So first, the FCC confirmed that the definition of automatic telephone dialing system covers equipment that has the capacity to store or produce telephone numbers and to dial random or sequential numbers. The Commission refused to exempt equipment that lacks the present ability or the ability at the time of the call to dial random or sequential numbers. It confirmed that equipment can be covered even if it is not presently used for such purposes or capable at the time of the call of utilizing a random or sequential number generator. It also confirmed that predictive dialers, as currently understood, in which the technology allows the caller to essentially create a calling queue to place numbers at such a pace as to connect an answering party with a caller's representative at about the same time. Those, regardless of how they're marketed and regardless of the specific configuration, do satisfy the TCPA definition of autodialer, even if they do not at the time of the call include a random or sequential number generator. And then the Commission also confirmed that the autodialer definition and whether your equipment is an autodialer, it doesn't matter whether calls are made with dialing equipment, whether it's designed to be paired with or operate independently of the predictive dialing software in the database of numbers. The Commission also declined to determine comprehensively each type of equipment that falls within the definition of autodialer. So once again, we don't have the bright line guidance on where the limits are between technology that qualifies as an autodialer and technology that does not. The Commission did confirm that there must be more than a theoretical potential that the equipment could be modified. In other words, and as stated in the order, a rotary phone is not an autodialer. But ultimately, the Commission calls for a case-by-case determination of the equipment. And then finally, the Commission confirmed that callers cannot avoid obtaining consent for autodialed calls by dividing ownership of the components of an autodialer among multiple entities. So in other words, two entities with separate storage and dialing equipment may effectuate a call that's subject to the consent requirements if the net result of that voluntary combination enables the equipment to have the same capacity that's covered by the autodialer definition. And so just a few of the bottom line takeaways here. I think you see the Commission looking to avoid creating any particular gaps or loopholes for parties and callers to focus on, and instead seems trying to direct parties to look at ways to obtain consent and to figure the autodialer component as one element of the overall compliance strategy, rather than focusing on a specific dialing method. So moving to the called party issue, this was something that had frustrated a number of callers because you have a situation under the TCPA where, under the statute, if you obtain prior express consent for placing calls to a specific telephone number, under the statute, you're allowed to place those calls, or at least that's what parties thought. They thought they were doing everything they were supposed to do. However, there are instances in which a number may be reassigned from one subscriber to another, and this is an issue that is focused more on the wireless to wireless reassignment context. It can also occur in other scenarios, but wireless to wireless was a situation where callers had seen they would obtain consent for a number, and by the time they placed their call, the subscriber had changed. So the party they were trying to reach was not the party that was answering the call. It was no longer the subscriber or the frequent user of that number. And parties had argued that once you obtain consent, and as long as you're intending to call the party that gave you the number, that should be sufficient. And there had been a lot of litigation on this issue, including class action litigation against a number of household companies. And what the Commission said was that the TCPA requires consent from the called party, and in this context, the called party is either the current subscriber or the customary user of the device. So you have to obtain consent from either the current subscriber or the customary user. It expressly rejected the intended recipient approach, or the intended party, that a number of industry petitioners had requested. However, the Commission understood that there were a number of challenges in trying to protect against all possible calls to a reassigned number. And so it developed a solution, or a perceived solution, I should say, in which you, as the caller, as long as you have a reasonable basis that you have obtained prior express consent to call that number, and that you don't have any actual or constructive knowledge of the reassignment, then you may place one additional call after the reassignment occurs in an effort to potentially obtain knowledge of the reassignment. But you only get one call, and effectively it's a one attempt approach, the issue being that the Commission said the call does not have to be answered. Even if you don't talk to someone on the other end, even if there's no message on the voicemail that indicates the number's been reassigned, that is still your one call. So therefore, the burden remains on callers to be doing everything they can and taking all of the steps that they can to try and prevent calls to a reassigned number. The practical problem being, the challenge here is you don't know when you've made that one call, and so you may very well make more than one call, multiple calls, dozens of calls by the time you learn about the reassignment. With that said, the Commission included in the decision a number of best practices that companies can use to learn about calls to reassign numbers, such as working with third parties to supplement their databases and identify reassignments and obtain verification on the current user of a number, putting in your terms of use and agreements with your account holders and customers that they will inform you about the reassignment, providing an interactive opt-out mechanism on a call, recording and tracking wrong number reports, sending emails asking for updated contact information, and a number of other examples. Nonetheless, I think at the end of the day on this one, it's still a difficult compliance framework for callers, and under this decision, which again has been appealed, you are expected to be taking a number of steps to protect against these calls. The Commission also addressed in this one the issue of the extent to which consumers can revoke their prior express consent. And it confirmed relatively briefly that a called party may revoke their consent at any time through any reasonable means. They can revoke their consent either orally or in writing, and the callers may not abridge the consumer's right to revoke consent. I think there still are some unsettled issues here. It's not clear what reasonable means would be here, but it is helpful to know that it's not a one-size-fits-all compliance burden. The Commission did mention that certain reasonable opt-out methods could include a customer-initiated call or an in-store bill payment location. And then finally, on number porting, the Commission confirmed that porting a number from wireline to wireless does not revoke the consumer's prior express consent. However, you do have to make sure you have the requisite consent for the ported to platform. So if you had obtained consent to place a call to a wireline number or landline number, which is the more permissive approach, it may be the case that your consent is not robust enough to allow for the consent to suffice as calls to wireless numbers. So keep that in mind, and you want to be doing what you can there to identify the porting and make sure that you've got appropriate consents. So real briefly, discussing the additional items that I mentioned at the beginning of the slides, the Commission also created two key exemptions going forward for the financial services sector and the healthcare sector. These, again, are prospective exemptions and are subject to a number of conditions, but ultimately are designed to facilitate what the Commission views as pro-consumer calls. So, again, these are prospective only, and also it's worth noting that they are required to be free to the end user. So callers that wish to make use of these exemptions have to work out an arrangement with carriers or aggregators to be able to place the calls or text messages at no cost to the consumers. And that's something that's not an existing requirement on the non-exempt call. So if you get consent, you don't have to worry about the charges to the end user. But if you're going to rely on the exemption, you do. The Commission also addressed who is the maker of a call and established a fact-based approach, looks at the totality of the circumstances, including who's involved with making the call and who is very active in the direction and content of the call, and some other pieces as well. The Commission confirmed that text messages are calls, and included a discussion about certain types of text messages that now qualify as calls and had not previously been addressed by the Commission. So we'd had some prior language about SMS, and now under this order some other types of text messages to telephone numbers are covered. It clarified a few wrinkles regarding its 2012 rule changes, including that parties do need to obtain consent under the new rules, even if they previously had obtained some form of consent in writing under the old rules. And then finally, the Commission confirmed that carriers may allow consumers at their discretion to implement call blocking technology, more specifically robocall blocking technology, and it discussed different mechanisms and conditions for that approach. And so with that, let me hand it over to Becky for the beginning of our Q&A session.
Great. Thank you very much, Mark. For me, at least, the declaratory ruling and order raises a lot of questions. I want to start with a general one. How are the FCC orders on TCPA used in court? In other words, in the lots of litigation that we've seen, is this something that plaintiffs will rely on in court? Is it definitive in terms of what the court does? One question you had said that the FCC and some courts have determined that texting is covered. Here now the FCC is reaffirming that. Does that mean courts are bound to or likely to follow that?
In many instances, they are going to follow the FCC's guidance, and similarly, in many instances, they are going to feel like they are bound by the FCC's guidance. But there's not a perfect overlap between those two. But I think what you see here is that courts will defer to the FCC's interpretation on some of the technical issues, as well as some of the practical or implementation side issues, because of the record the FCC's developed and has in the past on these calling issues. They are also bound by other statutes to follow and defer to what the FCC does within certain parameters. And that's why it was important that a number of parties that were unhappy with this decision appealed it right away, because otherwise the decision becomes you have the issue that the decision could become final and applicable to everybody, and you may not have the chance to appeal it in your individual litigation down the road. As to whether and how the plaintiff's attorneys will use, I was just going to say, as to whether and how the plaintiff's attorneys will use this, I think they will use the parts that they like, and there's enough in here that they can probably pick and choose a number of things to create a number of headaches for defendants.
So because the lawsuits were filed, does that mean that the effect of the order is stayed pending the outcome, or is it in effect?
No, the order's still in effect, and I think there's a number of points to make off of this. It's a great question, Becky. So the order was effective immediately, and nobody has filed a request to the FCC for a stay, nor has anybody filed a request to the court hearing the appeal for a stay. Now, those still may appear, but nobody has made a request yet. Now, a number of TCPA cases had also been stayed pending the FCC's review of these issues. Now that the FCC has issued its decision, it remains to be seen what will happen in those cases as to whether parties will seek a continued stay while the court appeal of this declaratory ruling and order continues, and so forth. But for now, the order is effective and is also, because of its retroactive applicability, relevant to all of the pending cases, whether they're stayed or not.
Okay, so the question of what is and isn't an autodialer, that's been something we've been talking about for a couple of years now, with a lot of energy. Here, the FCC specifically rejected the present capacity argument. In other words, it doesn't matter. It doesn't matter if it's being used as an autodialer, but if it has the capacity. But they even went a little farther and said if it's something that can be readily modified to have that. So, for example, they said even if you have to add some software, that's covered. Is there anything in between is there anything short of retrofitting a rotary dialer to become an autodialer, which even the FCC agrees is unlikely? Is there anything short of that we know isn't an autodialer?
Well, this is such a frustrating scenario for parties that are trying to place calls with any level of efficiency, but also for anyone that's simply trying to comply with other legal requirements and connect on limitations on the number of attempts, or trying to make sure they place calls only during the designated calling windows during the day and so forth. And so I think what you have in that scenario is a situation where it's very difficult under the current language of the order to provide much in the way of guarantees or clarity as to a specific scenario, a specific solution, and say that is undoubtedly not an autodialer. And so whereas we used to have a number of things we could point to be increasingly comfortable on different technologies, and some more than others, now it's much more difficult, and instead it becomes a matter of what level of risk appetite you might have and what types of arguments you can make for and against the solution. No doubt the plaintiff's bar is going to look to stretch this decision even farther than what the FCC said. But there are some things that I think are very important. You pointed out the software piece. There is a footnote. It's footnote 63, which says the functional capacity of software-controlled equipment is designed to be flexible, both in terms of features that can be activated or deactivated, and in terms of features that can be added to the equipment's overall functionality through software changes or updates. Now, it's not clear here whether the FCC is trying to create a software-hardware modification distinction, but I think there is a signal here that if all the equipment would need is some software changes, that's something the plaintiff's attorneys will point to, and use that to their advantage. The question that remains unanswered, however, is what level of modification would be enough to keep your to make it more like a rotary phone than an autodialer. And there's another statement in the decision in which they confirm that a telephone handset with nothing more than speed dialing added is not an autodialer. And so we have that parameter as well, but again, after that point, there's a lot of conflicting language. And so, there will be parties that argue that you can, there has to be some limit on software modifications. It can't be only a hardware-software distinction. We just don't have clarity from the FCC that would prevent a plaintiff's attorney from arguing the opposite side there.
So how do you see this affecting litigation?
Well, I think it's going to be very difficult now. Again, unless the appeal has the order vacated, but it's going to be very difficult under this order for defendants to have a case dismissed on motion to dismiss or summary judgment. And the result of that is that more and more of these cases are likely to either settle quickly or go to discovery, which has been a big problem from the defense side and having to go through the expense of the discovery. So now you're going to have more reasons for the court to seek discovery, or for the plaintiffs to push for discovery on the equipment at issue, rather than simply the calls that were being made and and the circumstances surrounding the consents. And I think the practical result for someone who's trying to develop a compliant approach is to look for ways it's time to take a fresh look at your compliance approach. And to the extent you might have been shifting more on a calling approach solution as opposed to a consent solution, now I think you have to take a look at, once again, what types of calls you're making, what the potential for lawsuits and the optics on the calls you're making, how likely, what's the overall optics with the calls, what level of risk appetite do you have, what's the purpose of the calls, and how critical are they to your business mission, and how do you work within these so-called clarifications that the FCC has given, at least until we have more clarity from the appeal.
Thanks. Okay, let's talk about revocation. The order says that you can't, that you must permit consumers to revoke consent through any reasonable means. Is that as broad as it sounds? If somebody calls the wrong department in a corporation, or if somebody says at the checkout counter, by the way, I don't want any more telephone calls, is that enough to create a revoking consent? And what are people going to have to do to deal with this one?
Yes, this is another critical question now on the compliance side. And it's unfortunate that the discussion in the order is actually, I mentioned earlier, it was a brief discussion. I think it's something that the FCC created a number of new confusing scenarios, and as with some other areas in this decision, really opened itself up to further requests for clarification. I see here. No, I don't know that the FCC is trying to create some type of heavy new burden on industry, but rather was responding to information in the record that some parties, just as a very broad example, some parties might have had 12 different ways that somebody could opt in to receiving calls, but then might specify one way and possibly one difficult way that, the only way that you could opt out. And they were trying to protect against that potential imbalance. So I don't know that this order necessarily requires parties to open up new channels for receiving the consents that had not previously been a channel for the company to communicate with consumers. But if you have outbound lines or you're placing outbound calls, then anything that you were looking at as a one-way communications tool, it probably now is something to reassess as maybe being a two-way communications tool. So if they can opt in on a particular channel, you probably want them to be able to opt out. And it's also something that you can take a number of steps to try and inform consumers. Be clear in your disclosures and your contractual terms, because courts will look at those issues. They'll look at what you told the consumers and when, and ultimately there's likely to be some tension here between what the FCC says and how that's interpreted versus what a two-way contract between a consumer and a company will be viewed to control. So that's something we're going to see going forward. But ultimately now, in the short term, you want to make sure you have the ability to effectuate the opt-out request promptly across your channels. And I think that does lend itself to finding new resources to handle customer preferences and keep tabs of your database management.
Okay, that's going to cause some thinking here. And then finally, on the reassigned numbers issue, a lot of the petition asked the FCC to solve this problem. Some of them asked for, a designation that the called party is actually the party you intended to call, and the FCC clearly rejected that. Other petitioners asked for a grace period of up to a year to learn about reassigned numbers. But the FCC rejected that, but then offered as a compromise this one free call condition, but says the caller has the obligation to demonstrate two things. One, that they had a reasonable basis to believe they had consent to make the call, and they had no actual or constructive knowledge that the number had been reassigned. So what is constructive knowledge here?
They have created quite a mess with this, and it's something that we are sorting through a number of channels and trying to understand more about what parties really should be doing here. But yes, as you noted, the order says that the caller bears the burden of demonstrating that they had a reasonable basis to believe they had consent to make the call, and that they did not have actual or constructive knowledge of reassignment prior to or at the time of the additional, the one additional call window. I think constructive knowledge actually means different things at different places in this order, some of which are consistent with well-settled legal interpretations and others that are not. So starting first with this notion of making sure that you don't have constructive knowledge of the reassignment before you place the call. Constructive knowledge is generally used as something to, it's one side of the line and the other is actual knowledge as far as the ways in which you can obtain knowledge or deem to have knowledge. Actual knowledge, an example there would be the consumer telling you directly, my number has been reassigned. Constructive knowledge would be something more indirect, not necessarily guaranteed, not always perfect, not accurate, but enough to provide some indicia that maybe the number has been reassigned. And, I think, for example, if you, leaving the telephone context, if you were looking at constructive knowledge of on a postal mail or something like that, and constructive knowledge versus actual knowledge there would be more likely when you get the official U.S. Post Office notice of address change. The constructive knowledge might be something more like you had, you start receiving payments back from the individual and they're coming from a different address on the envelope. And at some point the two start to blur, but the idea would be one of them is much more direct than the other. And when I say the order conflicts a bit, the FCC said that after the one call, after the reassignment, the caller is deemed to have constructive knowledge of the reassignment. And I find that to be a bit in tension with the well-settled interpretations of what constructive knowledge is. Because there are many instances in which a caller might be trying to place a one-way communication, an alert, a notification, something that requires no response from the consumer. And under this order, if you place that one call, even though you'd have no reason to expect that anyone would reply to you, even if it's the same consumer, then the order deems you to have constructive knowledge in the scenario where there's nothing but silence. And that doesn't seem quite right, and I expect that to be one of the key issues that will be appealed as part of that section of the appeal. But nonetheless, constructive knowledge would be the notion of indirect knowledge, not necessarily conclusive, but now under this order, I think that's something where as a regulated party, you want to make sure you're taking the steps to act upon and inquire further whenever you obtain information that may constitute constructive knowledge. So now your compliance programs need to build in mechanisms to help identify areas of constructive knowledge.
But if you make a telephone call to a reassigned number, if you make one telephone call to that reassigned number, even if it's not answered, you're deemed to have constructive knowledge.
That's right. You get no more, no less from the FCC in that situation. You get the same one call and only the one call.
So constructive knowledge is really, if that part of the order holds, isn't really much relief. Doesn't sound like. The order lists a variety of best practices that for learning about reassigned numbers over time. Some of them seem to give some false hope. For example, they say you can ask consumers to tell you if they've turned in their number, but of course they don't have to, and it's still on you to deal with the constructive knowledge after you've made one call. Or you can send folks email notifications and ask them either to confirm or to let you know if the number has been reassigned. Again, that doesn't get you out of the penalty box if the consumer that you're asking for information from doesn't provide it, I take it.
It does not, and as long as let's all be. We can all say in unison that the FCC seems to have left reality for this part of the decision, because they're recognizing that there's not a foolproof structure here, and that no matter what steps you take, this scenario could still occur, but they still left the burden on the caller to minimize the number of calls to reassign numbers. And so from a certain point of view, as a caller, you should be taking any and all steps just as a liability reduction measure, and then sorting through where if you have to draw lines, you figure out which ones make the most sense for your particular business lines. But no, the FCC says in here that these steps are not a safe harbor. You still only get the one free attempt. And when I say we've left reality, I mean there's a footnote in here that says even if you try to have a contractual agreement with an individual that says they'll update the number promptly, and you try to seek indemnification, that's not going to protect you against the call to the subscriber that has the reassigned number. And yes, in footnote 302, they do mention how parties can start suing their own account holders and customers as a TCPA protection measure.
That's what we all want to.
Yeah. I mean, that's just it is not the right solution, but it is the decision we have from the FCC. And it requires now, just as a practical measure, that you take a fresh look and see how you can prevent these. And one of the steps mentioned is to reach out and obtain number verification services that are available, and to look at your customer preference management and your porting records and your account and consent records, and see what you can do it's just a much more 360 approach than I think a number of parties used to take. I think previously you used to have a major threshold question, and that was, am I using an autodialer or not? And now I think it's much more likely that parties are going to be looking at the full suite of compliance and risk areas on these issues.
Okay, thanks. Tom, shall I turn it over to you to take some questions from the audience?
Sure. We actually have a lot of questions. We have some questions on appeals, constructive knowledge, best practices, autodialers, and a few others. I think a good place to kick this off, kind of to go with Becky and Mark, is on constructive knowledge. Somebody asked the question, if you autodial a phone number and you don't get an answer, is that considered, would that be considered constructive knowledge on that for that call?
It is. There's a statement in the order that in making your one call after the reassignment, assuming that you met the requirements for that. Remember, you have to have a reasonable basis, and you can't otherwise have constructive knowledge or actual knowledge of the reassignment. But if you're eligible for that one free attempt and you don't reach anybody, that's still your attempt. Now, the order does not specify what happens if you start dialing but it doesn't ring, or all those sorts of things. I expect that telephone records are going to be the decision maker there. So if your phone company records something as a call, that's going to be possible evidence for the plaintiff's side. But yeah, that does count against you even if nobody picks up, and that's one of the key weaknesses in this order that I expect to be appealed.
Another question was on porting. So if a phone number is ported and a business has no knowledge of that port, will they still be liable if they call that phone number? Or if they auto-dial that phone number, is probably more specifically.
So
I think the answer is, go ahead.
That's right, Becky, go ahead.
So I think the answer is yes, if they don't have the requisite consent. So you port your landline to a wireless number. If you had previously given consent to get auto-dialed and pre-recorded calls at your home number, then that would work. But the chances are, since you don't need to get robust consent to make auto-dialed calls to a landline, chances are pretty slim that you would actually have that consent in hand. Now, maybe going forward, folks will get it, but with respect to existing customer base, you are liable if you call a wireless number without the appropriate consent for auto-dialed calls.
And there is a grace period for wireline to wireless service under the FCC's rules. So the scenario that drove the reassigned numbers discussion in the order was wireless to wireless reassignments, for which there is no grace period set forth in the rules. So that's something where you'd have to balance that. But again, it underscores the need to identify and make sure the company is aware of when numbers are ported, whether wireline to wireless or wireless to wireless.
Right. That is hard. The wireless to wireless is hard to do, and our studies show that something like 70% of wireless numbers that are turned in are reassigned in a very short amount of time.
So with that in mind, I think we got a lot of questions on, well, what do we do now? Really, kind of what best practices do you recommend for companies to protect themselves against unintentionally dialing wrong phone numbers or auto dialing wrong phone numbers? Maybe Becky,
well,
you can jump on that, or Mark.
Yeah. Maybe Becky, if you don't mind starting.
Yeah, I think that the language of the order is sufficiently vague that we can't say for sure, but it does sound like the FCC at least would be looking at, they've described best practices using providers who can tell you the likelihood that a number is still associated with the same subscriber as it was when you got email. There are some of the other best practices, so-called best practices that the FCC listed that are not going to be particularly useful, like asking people to notify you, but maybe you want to do that anyway, so that you can demonstrate sort of that you've taken a holistic approach to trying to be informed about reassigned numbers. But as we know, there are things that can help. there is nothing that can fix this problem right now, particularly in the wireless case. But I just have one question. I was just thinking, I mean, what do you think the courts are going to do with this FCC notion that these things are best practices? Is there going to be a higher expectation by courts that you are following best practices?
I'm not sure all courts are going to do the same thing, but I don't think they're going to do much with it. And it's interesting because the FCC ran into some trouble a few years ago in its 2013 DISH declaratory ruling, where it determined a legal standard that parties needed to follow, and then tried to give guidance as to how to implement that standard. And the scenario is a little bit different than what we have here, but ultimately the FCC there was saying, for a certain issue of vicarious liability, you need to look to federal common law agency principles. And then, again, they started giving some examples. And the court on appeal said, look, once you've decided what the standard's going to be, given that the standard is something the courts apply, you should not be saying much about it, and struck away those parts of the order. Here, I don't think we have that same deference to a court standard, but I do think we see a distinction between the best practices and the legal requirements. What I would expect, how I expect this language to be used, is as support for the policy outcome here, and support for what the FCC is trying to accomplish from a policy perspective. And ultimately, as this decision goes up on appeal, I think the FCC will try to cite to some of this type of these best practices as things that callers can do to prevent this problem, so that it can explain to the court that its decision isn't quite as bad for callers on this issue as the appellants will make it out to be. But I don't think from a legal perspective the Commission has a good hook here to require these, because it's also, because it's retroactive, because it's a declaratory ruling, they can't make up all of this out of thin air and then not tell you it's a requirement. There's already a problem with trying to make up this one call solution out of thin air. If they tried to double down and say that any or all of these steps were necessary as well, I think that's going to be trouble. However, it's not out of the question that somebody could say, look, you failed to do any of these steps. How could you possibly still have a reasonable basis for your consent 5 years, 10 years down the road after you obtained it? So don't cross out the possibility that someone's going to take this to the extreme for callers that maybe get consent but don't have to place many calls or don't have to place calls frequently. It's something to keep in mind as to how this could be manipulated by the plaintiff's bar. And again, it really comes down to making sure you do take some steps and take a fresh look at your compliance approach because of the different ways that this can be looked at.
Okay, thank you very much.
And if anybody's interested, I have some more detailed slides on some of these issues that I'm happy to share. So just send me an email for anybody on the line that's interested.
And we will.
For everyone.
I just wanted to say we will go through the questions that are in the notes that we didn't get to and try to get answers to folks.
Yeah, we had a lot of questions today, so we'll definitely be answering kind of all the questions and getting back to people. And we just wanted to thank both Becky and Mark for taking time out of the day to talk to us about TCPA. And if anyone on the call has any questions around TCPA and they didn't get a chance to send them in, we'd be happy to discuss those offline, and we could either set time up with one of our consultants or someone from our product or legal organization to kind of talk through some of these issues in more detail if you'd like. There's contact information on the slide if you'd like to contact us. And thank you very much for your time today.